The ATF and multiple gun control advocacy groups have joined together to argue that the Supreme Court should grant review in the Cargill v. Garland bump stock lawsuit, and ultimately that the Supreme Court should protect the ATF's bump stock ban. Recently, the Fifth Circuit en banc panel ruled in the Cargill v. Garland case, and they found that the ATF's final rule on bump stocks is in fact unconstitutional and invalid. This decision by the Fifth Circuit struck a major blow to the ATF's current overreach and also their claimed authority. In this important decision, the Fifth Circuit en banc panel found that the definition of a machine gun, as outlined in the NFA and GCA, does not apply to items like bump stocks. That ruling has major implications not just for bump stocks, but also it will impact other ATF rules like the rule on frames and receivers, and also their pistol brace ban. And right now, the ATF and gun control groups are asking for the Supreme Court to review this case, to take up review of this lawsuit, and ultimately they want the Supreme Court to find that the ATF has this type of authority to create these types of rules which ban things like bump stocks. Now, before we dive deeper into what's going on with Giffords, Brady, and Everytown joining together to support the ATF in their request for Supreme Court review, I want to thank the sponsor of this video, which is USCCA. If you guys concealed carry, you also need to consider what happens if you must act and use your firearm in self-defense, or maybe you just need to act in self-defense generally. USCCA provides you with legal protection in the event that maybe, unfortunately, you find yourself in that type of situation. So if you're interested, check out USCCA using the link down below. Now, for those not aware of what this lawsuit involves and how this wound up in front of the Supreme Court, for many years the ATF had stated that under the NFA and the GCA's definition of the term machine gun, that it did not include items like bump stocks. However, after the incident in Las Vegas, the ATF, after being directed and ordered by then President Trump, also in association, I guess, with the NRA according to Trump, they decided the ATF to arbitrarily change the regulatory definition of a machine gun so that bump stocks are now considered to actually be machine guns. One of the important aspects of this challenge was whether or not Chevron deference should be given to the ATF in relation to their final rule on bump stocks, or whether a different type of rule or a different type of doctrine called the rule of lenity would direct courts on review to rule in a way that is most favorable to us, the people, instead of the ATF. Now, in a 13-3 decision, an en banc panel in the Fifth Circuit found that the ATF overstepped its authority in regulating bump stocks as machine guns under the GCA. In that decision, the court stated that a plain reading of the statutory language, paired with close consideration of the mechanics of a semi-automatic firearm, reveals that a bump stock is excluded from the technical definition of machine gun set forth in the GCA and NFA. In that decision, the en banc panel clearly identified that the definition of a machine gun in the GCA and the NFA does not include items like bump stocks. And even if that term were considered ambiguous or vague in some way, the court said that they needed to conclude and they needed to use the rule of lenity, which would direct an interpretation in favor of us, the people, and would go against what the ATF is saying that these items are machine guns. Now, after the Fifth Circuit en banc panel issued that decision striking down the bump stock ban, the ATF then filed for Supreme Court review. They filed a writ of certiorari up to the Supreme Court. This is important because you have the ATF on their own having to go to the Supreme Court and are now requesting for the Supreme Court to take up this case to review their bump stock ban, and ultimately they are requesting that the Supreme Court side with them, finding that the ATF has this type of authority. Traditionally, the ATF would never want the Supreme Court to weigh in on this type of issue, but because the Fifth Circuit en banc panel issued a pro 2A decision, essentially the ATF's hands are tied and they have to go to the Supreme Court. Well, in response to all this, the ATF just received support from all of the anti-gun advocacy groups, which are Giffords, Everytown, and Brady. All of those groups joined together to file an amicus brief to the Supreme Court, arguing that the ATF is correct and that these groups want the Supreme Court to rule in favor of the ATF. In their brief to the Supreme Court, they argue that bump stocks turn semi-automatic rifles into machine guns. That is their sole purpose. When a rifle is outfitted with a bump stock, the shooter need only pull the trigger once, and the gun will fire continuously so long as the shooter keeps his trigger finger stationary and applies forward pressure to the barrel. Put another way, they say, the bump stock makes the rifle fire repeatedly with a single pull of the trigger. that makes it a machine gun. So essentially no surprise that these anti-gun groups are arguing that bump stocks make a firearm automatic, and therefore, in their view, they are machine guns and they should be banned by the ATF. But in this statement here, they're actually doing something a little bit more. What they're trying to do is modify the actual statutory definition to meet their overall agenda. Here they talk about a single pull of the trigger. Now, why is that important? Why is that language important? Well, because the ATF and these anti-gun groups are adding language and terms into the definitions of a machine gun that you don't find in the NFA and GCA. Nowhere in the definition of a machine gun will you see the terms single continuous pull of a trigger. The language the ATF is using to claim these items are machine guns is completely made up by the ATF to justify their ban. They added this language into the rule. The actual language says single function of the trigger, not single pull of the trigger. This type of mechanical analysis is what the Fifth Circuit did in reviewing the bump stock rule, and on their own, they agreed that the function of a bump stock does not meet the statutory definition. Then later, they also argue in this brief, the anti-gun groups argue that the Fifth Circuit's decision is wrong and dangerous. If the court does not get this correct, if they don't get the correct ruling, they say that essentially millions of Americans will be less safe. A big part of this brief, when you read through it, is just simply those overall public interest arguments that we see them put forward all the time, that these items are so dangerous, they're used in so many crimes, and that's why they need to be banned. But one of the more interesting arguments they are trying to make in this brief is that the Fifth Circuit's decision relating to the rule of lenity results in criminal defendants getting away anytime there is some sort of ambiguity in the statute. They state that the Fifth Circuit's decision striking down the ATF's rule created a circuit split on an issue of national importance. While that is reason enough to warrant this court's intervention, the Fifth Circuit's decision rests on a novel holding that would require judgment in favor of criminal defendants whenever a court perceives any ambiguity in a criminal statute. This mutation of the time-honored rule of lenity intrudes upon Congress's Article 1 authority. The court should step in to safeguard the separation of powers on which our system of government depends. For these reasons, this court should grant certiorari and reverse the Fifth Circuit's decision. So there in that statement, you are seeing these anti-gun groups put forward two different arguments, which are really interesting because they go against what they traditionally like to argue. People on the left, or these progressives, or whatever you want to categorize them as, these anti-gun groups tend to like two different types of arguments. And in that statement, they're kind of going against their two typical type of arguments that they like. One of the things that they're saying is, well, this is going to let so many criminals out. But it tends to be the left and progressive side that I guess really does like types of policies that lead to more criminals going out on the streets, being released from prisons, and also much more lenient sentencing, and also like the whole no bond systems. So it's interesting that you have these anti-gun groups putting forward that argument. The other interesting position they're taking here is that this type of decision by the Fifth Circuit is a violation of the separation of powers, when in reality, it's interesting that they're putting forward that type of argument because traditionally the left, the progressive side, likes to blur the lines of the separation of powers. And that's really what's going on here. You have the ATF trying to be the judge, jury, and executioner on their own. They're trying to make laws on their own and then enforce them on their own. But here you have Brady, Evertown, and Giffords saying that, well, this decision is going to violate the separation of powers. This goes against what we traditionally have in our democratic structure, and therefore the Supreme Court here needs to strike down what the Fifth Circuit said in this case. So this is an interesting scenario where the ATF is in the position of pushing the Supreme Court to want to review this bump stock ban. We will see if the Supreme Court wants to take up this issue, but if they don't, well then this decision becomes precedent in the Fifth Circuit, and also we saw recently in the Sixth Circuit that also we got a pro to a decision striking down the ATF's bump stock ban. So this is expanding. And in my opinion, I think ultimately the Supreme Court will have to review this, and then we will see how they come out. They're also taking up another big Chevron deference case, which I did a video on, which you can watch. And if you want to learn more about that, you can watch one of these videos here on the screen. But as always, thank you guys for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.